In this class, we will discuss about the Employees Compensation Act 1923. Firstly, the object and the scope. The Employee Compensation Act 1923 extends to whole of the India. Secondly, it came into force on the 1st July 1924, and it is a Social Security Legislation Act. Okay, the Employee Compensation Act 1923 imposes the statutory liability upon an employer to discharge his moral obligation towards the employee when they suffer from any disability or the diseases during the course of the employment in the hazardous working condition. Okay, that means whenever your worker or the employee is suffering from any type of the physical disability or diseases just due to working conditions of the company or the industry, at that time it is the liability of the employer, or it is the obligation, moral obligation of the employer to give compensation to those employees. Last one, it is the aim of this act to provide the compensation to that particular employee, and also they will help the dependents of that particular employee to provide the relief from the hardship rising from the accident. Okay, and these are the amendments. Firstly, this act is known as the Workmen Compensation Act 1923, but after an amendment it is changes to Employees Compensation Act, and after this amendment some words and the expressions also changes. So before workmen, that is WORKMAN, and workmen WRKMEN, it is changes to employee or employees. Okay, next is the coverage of this act. That means which area is covered under this act. So this act is applicable to all mines, factories, plantations, transport establishments, construction works, railways, ships and circuses. Okay, and not applicable in armed force and the employees covered by ESIC Act 1948. Next is the definitions of this act. So under the section 2(1)(b) of the act define the commissioner's definition, that is commissioner for the Workmen Compensation Act appointed under section 20. Compensation is under section 2(1)(c), means compensation as provided by this act. Employer under section 2(1)(e), it includes anybody of the persons whether incorporate or not, any managing agent of the employer, legal representative of the deceased employer, any workmen whose services are temporarily or let on hire to another person or in a contract service with that particular employer, with that particular company, or work as an apprenticeship such persons while the workman is working for him. The contractor falls under within the above definition of the employer. That means the person who are working in any contract of the services with the company, they are also comes under the definition of the employer under section 2(1)(e) in Employee Workmen Compensation Act 1923. Okay, there are so many definitions which are given in the law, but right now we are covering this much only. Next is the employee. Employee under section 2(1)(n) as follows. Employee means any person who is a railway servant as defined in clause 34 of section 2 of Railway Act 1989, not permanently employed in any administrative district or subdivisional office of the railway and not employed in any such capacity as specified in schedule 2. Okay, first one is about the railway servants. Second is a master, seaman, or other members of the crew of the ship. Third one is the captain or other members of the crew of aircraft. Next is a person recruited as a driver, helper, mechanic, cleaner, or any other capacity in the connection with a motor vehicle. And last is a person recruited for the work abroad by the company and who is employed outside India in such capacity as is specified in Schedule 2, and the ship, aircraft, or the motor vehicle or company, as the case may be, is registered in India. Simply, we can say in point D, it is specified that any company which is registered in India and work in abroad, and if any person is recruited from India to work in abroad for that particular company, that person is also comes under Employee Compensation Act 1923. Okay, he can also stated as an employee under section 21N. Okay, employee in any such capacity as is specified in Schedule 2. 2. So, what is amendment in the Schedule 2? Before, the clerks were not covered under the Compensation Act. After, the clerks are now covered in the Compensation Act. Okay. Next is who are the dependent. Okay, it is specified in the section number 2(1)(d). Dependents, whether actually so or not, a widow, a minor legitimate or adopted son, unmarried legitimate or adopted daughter, a widow mother. Okay, wholly dependent on the earnings of the employee at the time of death. Who are the dependents? A son or a daughter who has attained the age of 18 years and who is infirm, and the dependent wholly or in part dependent on the earnings of the employee at the time of death. These are the wholly dependent person, and these are the wholly or imparted person, in part persons. Okay, a widower, a parent other than a widowed mother, a minor illegitimate person, son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married and a minor, or if widowed and a minor. Okay, a minor brother or an unmarried sister, a widowed daughter-in-law, a minor child of predeceased son, a minor child of predeceased daughter where no parent of the child is alive, a parental grandparent if no parent of the workman is alive. Okay, so all these are the dependents who are under Workmen Employee Compensation Act 1923 can be availed for the compensation if their employee is dead just because of the working condition of that particular company. Next is the disablement. That means what kind of the disablement for which the employee can uh, for which the employee can give its consent that he can apply for the compensation through employer. Okay, the act does not define the word disablement, but it defines the partial and total disablement. Okay, so first, what is the partial disablement? It means where the disablement is of the temporary in nature. Okay, such disablement as reduces the earning capacity of the workman in any employment in which he was engaged at the time of the accident resulting in the disablement. Okay, that means in the partial disablement, the first point is that your disablement is of the temporary in nature and you are not able to engage in your work after the accident. Second is where the disablement is of the permanent nature. Such disablement as reduces his earning capacity in every employment which he was capable of undertaking at that time. That means before accident, a person who is working on any area, but after accident he is having the permanent disablement so that he reduces his earnings. Okay, provided that every injury specified in part 2 of the schedule 1 shall be deemed to result in permanent partial disablement. In case of the temporary permanent partial disablement, the disablement results in reducing of the earning capacity. in respect of only that the employee in which he was engaged at the time of accident. So for that thing, the employee is avail for the compensation under partial disablement. So these are the two criterias which can become under the partial disablement under this act. Second one is your total disablement. What is the total disablement? The total disablement means such disablement, whether of the temporary or the permanent in nature, as incapacitates a workman for all work which he was capable of performing at the time of accident, resulting in such disablement. Okay, and all these total disablement comes under the part 1 of the schedule 1. Okay, and another thing that the combination of the part 2 injuries also come under the total disablement. That means in total disablement the person is able to uh, losses of his earning capacity, because he is uh, in the accident he just lose 100% of his body part. Okay, so these are the two types of the disablement which comes under the act, and these both disablement can avail for the compensation under Employees Compensation Act 1923. Next is under the section 3 of the act provides the liability of the employer in the case of the occupational diseases or personal injury or prescribed manner in which the compensation has pay to the workmen. Occupational diseases, which comes under part A of the schedule 3, part B of the schedule 3, and part 3 of C of the schedule 3. Personal injuries, the first one is the personal injury accident arising out of the employment, and in course of the employment employer is not liable when disablement not exceeding 3 days, accidents due to influence of the drink, drug, or disobeyed orders, disregards of the safeguard. These are the two important things in which we can say the employer is not liable to give compensation to the employees. First one is if the disablement is not exceeding the 3 days, and second one if the accident is occurred just because of the carelessness or the uh, discarding the safeguards or disobeyed the orders. Okay, so in all these things the employer is not liable for the compensation to the employee. Rest of the things we will cover in the next video. Thank you so much.